Yeah, I was thinking that too. Yep.
And what I'm going to do for this one is I'm going to just close my camera better, but I'm going to stay on just to make sure in case anything goes weird.
Okay, thanks. I appreciate that.
Okay.
Yeah, thank you.
I will leave it to you then.
All right, thank you.
Don't
We
forget
still
to
got
admit all when you're ready for everyone to join.
Okay, great. Thank you much.
All right.
Recording in progress.
Hello, this is Commissioner Michael Johnston of the Washington Supreme Court. We are here today on a motion for discretionary review directly in this court in the case of Washington Food Industry Association et al. Versus City of Seattle. The cause number is 99771-3. This is a motion for discretionary review of a King County Superior Court order partially denying a CR 12B6 motion brought by the city. We have a conditional cross motion for discretionary review, if you will, by the respondents, Washington Food Industry Association and it's Maple Bear Incorporated doing business as Instacart. Council, could you please announce yourselves and tell me who's going to be arguing?
Good afternoon, Your Honor. This is Jeremiah Miller for the City of Seattle, and I'll be arguing.
Right. And is that Mr. Rubens, I see? Are you going to argue for the respondents?
Yes, good afternoon. That's correct. I'll argue for respondents. Okay,
Mr. Miller, you're going to have, each side's going to have 10 minutes. All right. And Mr. Miller, would you like to reserve any of your 10 minutes for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal, please.
All right. If you just give me a minute. I'm going to set the stopwatch function on my iPhone and we can get started with that. Okay. Now, before we get started with the argument, I want to kind of lay out a framework, if you will. What we have here today is not just the motion for discretionary review, an interlocutory matter, but also a request to have the court have the matter heard in this court in the first instance rather than the Court of Appeals, which comes as a RAP 4.2. And so it's kind of a nuanced thing we're going to be doing here because we can either just send it straight back down to the Court of Appeals and have them consider everything in the first instance, or we can make a decision here and, like I could grant discretionary review, still refer it to the Court of Appeals. I mean, I have a number of different options. So we want to keep focused on those issues, the motion for discretionary review and whether to keep it here or transfer it to the Court of Appeals. All right. So having kind of laid that out, Mr. Aiken, you may proceed. Mr. Miller, rather. Mr. Miller, I'm sorry.
Thank you, Your Honor.
Yep.
The Supreme Court should hear the city's appeal in this case because the trial court's obvious legal errors will result in useless, expensive, and intrusive litigation, and they herald a return to a 19th century view of economic regulation and the court's roles in reviewing that regulation. Here, the city's ordinance is an exercise of its police powers, supported by many clear rational bases regulating economic activities. Among those rational bases are the compensation of delivery drivers for the risks that they face in doing their job. This basis was not even addressed by respondents below, and on its own provides sufficient rational basis for the law. Further, the trial court's errors below misapplied the proper balance between the city's police powers and the respondent's freedom to contract. This error represents a retreat to the Lochner error view of the balance between private business rights and the government's power to protect public health, safety, and welfare. The trial court should have dismissed the complaint in toto. The issues raised by the trial court's errors are ripe for review in this court. The trial court has determined that it must weigh legislators' motives and the empirical necessity of the economic regulation at issue here. And the trial court has determined that respondents' freedom to contract may be weighed against the police powers exercised by the city in passing the ordinance. Both serious errors of law will inform all further proceedings in this matter and represent dangerous departures from the law in Washington. In considering the city's motion for discretionary review and request for direct review in the Supreme Court, we would like the commissioner to consider the following 3 points. First, it is proper to grant discretionary review under Rule of Appellate Procedure 2.3b1 for the trial court's order because its errors of law in denying the motion to dismiss are carried through at every stage of the proceeding below.
Is it obvious error? I mean, what does it mean, obvious error, in this type of in this context?
Your Honor, in the city's view, the obvious error here is applying heightened scrutiny to an economic regulation that the parties and the court agree is due only rational basis review, and ignoring controlling precedent foreclosing the kinds of economic liberty claims that appear in respondents' contracts clause and takings claims. Okay,
this is a CR 12B6 motion, and so the standard is well, you know, for someone seeking dismissal, it's a pretty high standard. I mean, basically, under any set of facts, any conceivable set of facts, you know, if you can show that the claim is barred as a matter of law, I mean, couldn't one argue that this is sort of a debatable? These are sort of debatable issues, which would be more appropriate maybe for summary judgment, perhaps.
In our view, Your Honor, this is a clear question of law. For rational basis review, the question before the trial court was, could the city have rationally believed that the methods it had chosen would achieve its legitimate government purposes? The whole point of having that kind of lessened scrutiny review of economic regulations is rejection of the view that held sway at the end of the last Gilded Age.
Okay, so why here now rather than run it through the Court of Appeals in the first instance? This doesn't seem to be a statewide issue at this point. We're talking just about one city's ordinance. Is that correct? Why do it here now?
Yes, Your Honor. So in the city's view, the reason the Supreme Court should take this appeal is that the fundamental error that the trial court made is one which represents a real departure from the law in Washington regarding economic regulation. You know, the ordinance that is at issue here was passed, you know, during an emergency and was aimed at addressing both working conditions and public safety and health. These kinds of laws, if they become subject to claims that are meritless and then can proceed through the other stages of litigation, that's going to be a real problem. I mean, in this case, the reason to hear it now, the reason not to wait for summary judgment, is it will be the same argument at summary judgment. Whatever facts that respondents put forth to support the contentions in their complaint, because there are obvious rational bases for the law, and because their contracts clause and takings claims clause claims are barred by controlling precedent.
Counsel, it seems to me, counsel, that this is in a way, this is kind of a transitory issue in the sense that when the pandemic emergency concludes, hopefully, let's all hope that sooner rather than later, then the ordinance basically disappears, does it not? And so I think it'd be pretty tough, even in this court, to get something up on oral argument before the end of the year. And so it could be that the pandemic emergency could be finished by that time. So to the extent it's a purely legal issue, I mean, why rush it?
Well, for one thing, Your Honor, the way that the trial court below ruled is not dependent on the emergency nature of the law. The ruling below was based on commonplace attacks, or what used to be commonplace attacks on economic regulations. The trial court's ruling was not built around the idea that the pandemic was continuing, but rather what represented suspicion about the regulation of economic activities by the city, and a willingness to inquire into legislative motives and or the necessity of the law when there was no basis for heightened scrutiny.
You have about 40 seconds left.
Okay, well, I can. The only other point I would make that the Supreme Court could hear this or should hear this matter is that the effect of permitting these kinds of meritless claims to go through discovery, motions, practice, and a hearing is to really hamper legislative process, particularly when you consider that there will almost certainly be attempts to depose legislatures to determine what motive they had in passing the law. I'll reserve the remainder of my time for rebuttal. Thank you.
Good. Thank you. All right.
Good afternoon.
Yeah, just a moment, please. I want to reset my stopwatch. Okay. All right. Mr. Rubens, please.
Thank you. The trial court's decision is not a ruling that warrants an immediate appeal or bypassing the Court of Appeals. The question is why here and why now, as Your Honor asked. And the city has a lot to say about Lochner and the Gilded Age, but they haven't really answered those questions, which are what's now before this court, in a way that distinguishes this case from any other case where a motion to dismiss is denied. I want to be clear on what we're asking. As Your Honor noted, it's a little bit complex. We'd request that this court deny the motion for discretionary review. But in the alternative, the court could deny direct review and transfer the motion to the Court of Appeals. And if the court does
so just to clarify, so only if I grant discretionary review and that survives the motion to modify, only then are you requesting that we review the tax law question that you've presented?
Well, that's right. I mean, I think it could go down to the Court of Appeals and they would consider the motion our cross motion there. But we don't think there's a basis to proceed in this court before and bypass the Court of Appeals.
Okay, but wouldn't it be kind of beneficial to your clients if we kind of fast track things and it was reviewed in this court? I mean, your clients are the ones that are attacking this ordinance. So wouldn't it be kind of to their benefit to shorten the time frame, as it were?
I think this is really just delaying. This whole immediate appeal is just delaying things. I mean, we're trying to proceed with discovery. The city has been complaining about discovery, but they haven't even produced anything yet, well after we made our demand. And we want to just get moving on that discovery on the constitutional claims. And we're content to take an appeal from the dismissal of the preemption claim, if that's relevant at the end of the day. But our client's preference is to, keep on going in the trial court, as normally happens when a motion to dismiss is denied. I do want to address, the standard of obvious error, which is very important. It's different than probable error, which is another standard set forth in the RAP. And I think also it's really important to be clear on what the trial court decided on this motion. The court didn't make any ruling on the merits of our constitutional claim. It didn't enjoin anything about the ordinance, including its premium pay requirement. And as Your Honor noted, it is a transitory issue in terms of prospective effects because the ordinance is going to cease automatically when the state of emergency terminates, which presumably will happen before long. The order didn't really change the status quo in any way. It just allowed parts of the lawsuit to proceed. The city has, said a lot about consequences, but it really doesn't back up those claims. It's just, the ruling is just an application of a pleading standard, doesn't announce a new rule of constitutional law. It's not binding on any other court. Direct review on an interlocutory basis in this court should be reserved for a truly exceptional case, not a preliminary ruling in a lawsuit that the city just doesn't think it should have to defend. The city, is complaining about the cost of discovery and civil litigation. but those costs don't distinguish the city from the position faced by other defendants who lose a motion to dismiss. I mentioned discovery. Most of the documents we're seeking are public records, so it shouldn't be burdensome for the city to produce those documents. If the city believes that it is burdensome or that our discovery is inappropriate, it can object to those requests, as it's done already, and then seek relief from the trial court. But it's speculative to assume the trial court's not going to be able to supervise that process, and the city shouldn't be allowed to use that speculation to short circuit the normal courts of appellate review.
You mentioned a lot of the documents are public records. Have you also filed a public records request?
We have, and we're also pursuing it on the civil discovery track. But we want to get the documents about communications with the legislature, between the council and the various interest groups, and these are commonplace requests for understanding what happened. And if there's an issue with depositions or something like that, that can be adjudicated in the first instance in the trial court. It's not really relevant to the question of interlocutory review. In terms of the merits of the trial court's ruling, there's really just not obvious error here. The trial court recognized that this ordinance is unique. I don't think the city really disputes that the ordinance is unique. It's not just a compensation regulating ordinance, but it prevents us from adjusting our business model in response to those expenses. And we have allegations of pretext here. So there's really not a case on point, saying that something like this should be dismissed on the pleadings.
And as for the claims for relief, I know there's a claim for damages. That's just Instacart, right?
Yes, that's right. The damages claim is just on behalf of Instacart.
Okay. All right.
The city acknowledges that the trial court applied, it articulated the legal standard correctly in terms of accepting the facts pleaded in the complaint is true, recognizing that rational basis is deferential to the political branches and has to take account of the public health emergency. There's not a problem with the statement of the standard. I don't think you can really read Judge Scott's comments in the bench ruling as reviving Lochner at all, but the more important point is that the city's cases that it needs to demonstrate obvious error, they're not in the posture of a 12b6. So I just, you might be able to debate who has the better argument on the merits, but in terms of obvious error, I just don't think we're in the ballpark for that. And I can address that in terms of the particular claims. There are 4 claims here. So this case would go forward if any one of those claims is sustained.
You say there's 4 claims. You said there's 4 claims because I count like 6 or something. So
I guess it depends on how you count, but we claim that they exceeded the police powers, that it violates the takings and contract impairment clauses, and that violates the privileges and immunities and equal protection clauses.
And you have a 1983 claim, too, right? Yeah,
that's correct. I guess there are 4 kind of constitutional provisions at play is a more precise way of putting it. But I think the takeaway is that not all these claims are even subject to the rational basis standard, which is really the focus of the city's arguments in these motions. In terms of the claims that are subject to that standard, the city, we have responded to the city's hazard pay justification, and that actually supports our claim because it backs up the pretext, evidence of pretext here. There's just no rational reason to have excluded transportation network company drivers like Uber drivers who face greater hazards being in a car, with passengers than Instacart shoppers from the scope of this ordinance. Our allegations, which Judge Scott credited, are that this ordinance really doesn't further the public health, and it's just providing additional compensation without any direction that's actually used to take steps. And on our own, we've taken steps to help promote safety. And at the end of the day, on rational basis, we've cited cases saying it's not a rubber stamp. Pretextual laws don't satisfy the rational basis standard. The city might disagree with those cases or have other cases it thinks are in tension, but nothing that says saying, well, there's a question of fit, of pretext is not something that can resolve in this motion. Nothing to demonstrate that's obvious error. And then we have our takings claim, which is not a rational basis claim. It's been analyzed under the Penn Central framework for regulatory takings. And that framework is very fact intensive. It can't be applied coherently here on a motion to dismiss. I think the city's only argument against that is to rely on a Supreme Court case from nearly 100 years ago, Omnia, which distinguished between frustrating and appropriating contractual rights. But even if that controls here, we've alleged that the ordinance in effect appropriated our contracts by basically conscripting us to provide subsidized delivery services to the public at our expense. And the trial court thought it needed more facts to evaluate that claim, and the city might disagree with that, but again, that's not establishing obvious error. And there's a similar point in our contract impairment claim. The city's only response to that one is to say the ordinance is a valid exercise of police power, but that's begging the question. We're challenging whether it's a valid exercise of police power. And then again, you have to look at whether it's a reasonable fit between the means and the stated goals, and that the U.S. Supreme Court's cases that have conducted it as a fact-intensive analysis. So again, there's no reason to take up that issue in this context rather than awaiting a more developed record. And I can just briefly address our cross motion for discretionary review, which we would ask you to reach only if you're sort of entertaining the motion for discretionary review rather than denying it. And we're just asking for any review to include the dismissal of our statutory preemption claim under the Keep Groceries Affordable Act, because the ordinance imposes a tax fee or other assessment on the delivery of groceries. And I think it's a very straightforward basis to consider that as part of any discretionary review that's granted. We filed a notice for cross review on that question. And under RAP 2.4a, it makes clear that the scope of any discretionary review has to include the entire decision in this circumstance where we've cross-noticed a part of the ruling that adversely affected us, where we need affirmative relief. So, it would make no practical sense to exclude that. And then if the city were to prevail on the merits, there would just be a separate subsequent appeal. And I don't think the city has had any coherent argument for why that way of proceeding would make sense. So for all of those reasons, we'd submit that discretionary review should be denied, and the alternative that you would transfer the case to the Court of Appeals to consider the request for discretionary review. And to the extent this court does grant discretionary review, that review should encompass the entire decision, including the dismissal of our preemption claim.
All right, thank you. All right, just a moment, please. I'm going to reset my clock. All right. And Mr. Miller, I'm going to give you 3 minutes and 10 seconds. So you may proceed with your rebuttal.
So I just want to make a couple of points in response. First of all, the procedural posture of this case isn't a reason not to deny the motion. Denials of motions to dismiss that are based on errors of law are in fact granted discretionary review. We cited a couple of cases in our reply: Montgomery out of Division 1 in 2019 and Becker out of Division 3 in 2014. In some senses, a denial of a motion to dismiss that's based on a clear error of law is exactly what Rule of Appellate Procedure 2.3b1 is getting at. It's a ruling that permits that permits useless litigation to continue when it all should have been stopped as a matter of law. The second point I'd like to make is about the nature of discovery. Discovery is in fact ongoing. I dispute the respondent's characterization of the way discovery is going as just not producing or engaging in discovery. We've given answers and are preparing to produce documents. This isn't an dilatory tactic. We're continuing to participate at the trial court level. This is a good faith effort to get a clear error of law that has far-reaching consequences reversed. And insofar as characterizing discovery is no different than the PRA, I think that's just false. The PRA contains no mechanism, for instance, for depositions. And as a matter of fact, the kinds of discovery they want to do is precisely the reason why courts went away from heightened scrutiny of economic regulations. They're going to do discovery that is supposed to get at the hearts and minds of individual legislatures to determine what their motive was in enacting a piece of legislation. Absent a suspect class or a fundamental right, there's no way that the court can adequately try to even weigh those factors. I mean, they only come in when you're talking about fairly extreme cases. With respect to the merits of the claims, this has been briefed extensively below and argued in our briefs. Briefly, I will say that the takings claim is in fact foreclosed by Omnia. It's true that if you have a taking of property, and it's a regulatory taking of property, then typically courts apply Penn Central. But here, there was no taking, because the only way you can take the sort of incoherent rights in a contract is for the contract to be appropriated. That means the city has taken the contract and is running the contract for the city's benefit. And that is not what happened here. The Contracts Clause claim is foreclosed for a number of reasons. One of them is that the police power forecloses Contracts Clause challenges, but also a temporary emergency laws are not challengeable under the contracts clause. And there's also a rational basis component of contracts clause claims that has to do with whether or not there is a rational basis for the government action that impairs an existing contract. With respect to the equal protection claims, I mean, this is sort of the fundamental error of the court. These other errors I've pointed out are errors that are on their own reversible. But what the court really got focused on was a misapplication of Civil Rule 12b-6. It is true that that the court had to accept the pleadings, the pled facts is true, but it has to apply those to the appropriate law. And in this case, it did not correctly state the law. The question before the court on a rational basis review is, could the city have rationally believed that its actions would achieve its legitimate legislative ends? Again, tellingly, there is no attempt to even address that one of the legislative ends was compensation of delivery drivers for the risks they face.
Okay.
Thank you.
Yeah, you're welcome. I thought I had it on a silent mode, but apparently not. All right, thank you. Thank you both, counsel. It's a very interesting argument, very well argued. Pretty unique case. It's the times we live in right now with the pandemic. There's, like I said, there's various things we can consider. One is whether this case at this posture should be in this court at all. And so one option could be to just transfer it down to the Court of Appeals, the whole thing, including the motion for discretionary review and your conditional, cross motion. Or I can go ahead and make that decision. If I deny discretionary review, then we don't have to worry about we don't have to think about the transfer question. All right. Another option is to refer it to a department of the court, much like we would a petition for review, handle a little bit differently. Whatever I'm going to do, I'm going to make a decision soon. And so you can expect a ruling or some determination from this court sometime next week. And generally, we're able to get these done within a week. So we're going to try our best to do that, all right? And so I want to thank you both for your courtesies and your considered arguments. And I wish you have a good weekend and stay cool. Okay?
Thank you.
All right. You're welcome. You have a good day now. Goodbye.
Goodbye.